Madam, I am extremely grateful to several honorable members of the House who have expressed themselves at length on this particular bill. Madam, the object of easing the buyback procedure is really to add to the liquidity in the market and also use some reserves of the company, which is a transfer of that corporate wealth for the benefit of the shareholders. Several questions have been raised. I'll try to deal with each one of them. The honorable member who spoke towards the end raised an issue from an article in the Business Line as to why within this statutory change a provision had not been made that stock exchanges are required to be intimated every time a buyback does take place. Madam, we are not adding or altering the whole scheme of buyback. Buybacks as a concept under the Indian Companies Act was introduced in the year 1999. Whatever are the requirements in relation to the buybacks, they do remain, except for one basic change which have been brought about. That is, 10 out of those 25%, that is the maximum which is permitted, can be permitted by a resolution of the board rather than the original decision wherein it was required a special resolution of the AGM of the company. The requirement to intimate the stock exchange, even under the original law, was not a part of the Companies Act, but is a part of the listing agreements guidelines which have been issued by the SEBI. And those guidelines under which intimation has to be made, any decision of the company's board which alters the prices or alters the nature of the securities or the quantum of securities is a major decision by the board itself, and under the listing agreement guidelines of the SEBI is required to be necessarily informed to the stock exchange. That guideline remains unaltered and need not be substituted within the provisions of the Companies Act itself. Madam, a question has also been raised as to whether there is any kind of alteration in the concept of corporate democracy. In the scheme of the Indian Companies Act, there are several powers which are exercised by the board. There are several powers which are exercised by the AGM of the company. A board is a donee of the jurisdiction which the Companies Act confers upon it, or the jurisdiction which the AGM may decide to confer upon it. The fact that there are two different organs under the Companies Act which exercise respective powers does not in any way show that the corporate democracy in any manner is being altered. Quite to the contrary, when 10% of these powers are being exercised by the board, that's a power which now under the Companies Act itself is exercised by the board, just as several other acts are exercised by the board itself. There are several powers which are under the Companies Act jurisdiction of the board itself. That does not mean that the Companies Act corporate democracy in any way stands denuded. Mr. Sibal raised a very important question, whether this could be at some circumstances misused by a set of promoters for their own benefit or for the benefit of persons close to them. Let me just explain how this will really function. When a company decides to buy back either 10% under this change or 25% under the original law, the price at which it will buy back is not the price which the company decides as a predetermined price. The price varies from a day-to-day basis as far as the stock exchange is concerned. The price is decided by the market itself. A company may well start buying back. It may be able to buy 0.25% on one day, another 0.5% on another day, and as the purchases continue to increase, it is anticipated on reasonable market behavior that the price of shares, because of addition of liquidity to the stock market, as also the demand of that particular share being increased, the price can move up. Once the prices go up, Mr. Basu raised a question, what is your experience that why will this itself lead to an increase in prices? This itself, Mr. Basu is right, is not a complete answer to all problems which exist in the stock exchange. Several steps are required. And he's absolutely right when he says the credibility of the stock market operations in India has to increase and improve for the ordinary investor to have faith in that credibility and become an investor. But adding to the liquidity of the stock market, converting certain reserves into the liquidity process in the market, creating a demand for the shares of respective companies, and once there is a demand for a large number of companies, because a large number of companies may go in for a buyback. You asked a question, how many companies have done it in the past? I tried to check up under the 1999 change law.
After October 20.
No, I'll answer the question. A total amount of 1,467 crores by a buyback process was added to the liquidity of the market after the 1999 buyback changes. After October 23rd, let me give you two figures. The values on the stock exchange, and again I am saying, values are not determined on the stock exchange by one factor alone. Sentiments do make a difference. Future potentials make a difference. Steps taken by the government may make a difference. Improved prospects of a quarter may actually make a difference. Performance may make a difference. FII investments may make a difference. There are several factors which add to it. On both counts, I found out, we have so far, through this intimation by the disclosure scheme, received intimation that under the new ordinance, already 3 companies have intimated to the stock exchanges that they have decided to utilize it for the purposes of buybacks.
They have not done the buyback yet.
So the buyback process will start once it...
in other words, after October 23rd till date, there is no buyback yet by any company.
The process starts.
I'm only
The
asking
process
a fact.
starts. Very well. The process starts. Whether the buybacks have started or not, but we have intimation of resolutions.
I'm sorry.
We have intimation of board resolutions of 3 companies so far.
In your original statement, you made a solemn statement on the floor of the House that already, because of buybacks, you think that the share prices have gone up. Which is why I asked the question. So it's now clear that there has been no buyback after October 20th.
Allow me to complete. A buyback process under the original special resolution process has been going on. I've given the figures. Under the new change, 3 companies have already availed of it. We have intimation of the board resolutions. On account of several factors, and this is one of those factors, from 23rd October till date, the percentage change in the value, in the Sensex figures itself, there has been a noticeable improvement. The figures are also before us.
I think again you are getting the facts wrong. Facts wrong because...
Let him complete.
Let him say. No. He is giving certain... no quarrel. I am just pointing out. Look, one is that, see, the contribution of this new ordinance is minuscule in this whole thing. Because the share market had come to its rock bottom. I mean, it could not further go down. And that 1,400 crores, the figure you are getting, it is also totally insignificant in terms of the total amount of the loss that has taken place in terms of market capitalization. It is also insignificant as compared to the amount of liquidity that was artificially generated by the brokers, sometimes in nexus with some of these promoters at the time when the market boomed.
Madam, give me a minute. In fact, our inquiries have in fact revealed that in the past, and the minister is right, the price will be determined by the market. In the past, what has been happening is that companies have been using certain institutions, I won't take their names, and certain entities to jack up the price of a particular script, so that when the price is high, they can purchase those scripts to benefit themselves and buys those very scripts when the price goes low a week hence. So the point that I am making to the Honorable Minister is that this is precisely why we are subjecting this bill to the caveat that we have placed before you, namely that this is going to be used by promoters for the benefit of their members of the family and to their associates.
महंगा होगा तो क्यों खरीदेंगे? सस्ता होगा तब खरीदेंगे ना।
कैश रिजर्व से अपने आप को पैसा देंगे। सिंपल, आपके पास 30% अगर स्टॉक है अपनी फैमिली मेंबर्स या आपके एसोसिएट्स का, तो उसको हाइक करके कैश रिजर्व्स कंपनी से उनको पैसा दे देंगे और वही शेयर फिर जाके मार्केट में जब दाम सस्ता हो जाएगा सस्ता खरीद लेंगे। ये तो साफ जाहिर है और ये होता रहा है। दिस इज पार्ट ऑफ द रीजन ऑफ द स्टॉक मार्केट स्कैम।
ये मंत्री जी
मैडम
इसीलिए
I elaborate?
मंत्री जी मूड में हंस रहे हैं इसीलिए।
Let me elaborate, because the illustration quite is not as explicit to be.
अच्छा सुझाव क्या है? आप सुझाव दो।
एक मिनट गौतम साहब।
आप बताओ।
Madam, the buyback adds.
Let me hear.
The buyback adds to the liquidity of the market. The buyback generates demand for the shares of a particular company which is being subjected to a buyback. The buyback benefits the values in terms of all shareholders of the company. Here you have a company which has large amount of reserves. The price is quoted at a price even lesser than the reserve as the balance sheet price. The shareholders have no option but to sell it at the depleted price, at the depressed price. Once the company indulging in a buyback starts buying and generating the demand, These shareholders have an option to sell, the prices move up. It benefits the shareholders who are going to sell. The shareholders who are not going to sell and who have a capacity to hold on, the corresponding value of their shares also increases because the shareholding base of the company gets contracted, gets reduced to the extent of the buyback. So this kind of an illustration that promoters will start selling their shares, the tendency of the promoters, it's a well-known fact, the general tendency of the promoters is not to sell but to consolidate their holdings. Promoters remain in control by consolidating their holdings, not selling their shares in the market and reducing their holdings. So this kind of an illustration which Mr. Sibal mentions, in a hypothetical case, if it is possible, it may be some promoter who's defying the normal market logic. This actually goes to the benefit. This normally, promoters consolidate their holdings.
The promoters will manipulate the market. It is
Well, promoters manipulate the market, the promoters will be taken to task for that.
Let him complete
The
his
promoters
answer.
who manipulate the market will be...
Why Mr. Nariman, the honourable member, suggested bills of this nature should not be introduced the ordinance route, because we need a thorough discussion of bills of this
Because we are
nature.
having a discussion on
But
this.
this is no way, because you
We
need
are
to
having a
send it
discussion
to
on
the
this.
standing committee.
We are having a
What kind of-
discussion on
this is the problem.
Therefore, madam, the normal principle behind a buyback is that buyback not only adds to liquidity but creates a demand. It raises the prices of the shares, and small investors of a company who otherwise had no option but to sell at the depressed prices today have a better option. Shareholders across, whether they want to sell, they want to hold on, are going to universally benefit once the market sentiment itself improves. And the fact of the matter is, amongst various factors in the last few weeks which have contributed to a somewhat improved market sentiment, this certainly has been a step in that direction. Mr. Nariman, madam, made a very valuable observation with regard to ordinances. I completely agree with him that the normal rule being ordinances are not to be resorted to, particularly when subject matters are of such a nature that they can always await when the parliament assembles and they can be taken up in parliament. The government is very conscious of this. And I can tell him that every time a suggestion for an ordinance comes, one of the first questions we address ourselves, can it not wait for the next session of parliament, or is it so urgent that it must actually take place before the parliament is ready to assemble? Here is a situation where the market sentiment, which since the month of March this year was already depressed, March this year, please. March this year, because the Sensex value was over 4,500, around 4,200 during that period. Market sentiment, which was depressed since 15th of March, particularly this year, after 11th September, world over, steps were being taken when the markets went down. Several steps were required to be taken to improve the market sentiment, and therefore this was a matter which required to be dealt with, and that is why the government overcame this initial view that we have, that normally we try and issue ordinances, that we did issue this ordinance in the middle of October this year, so that the market sentiment itself could be somewhat responded to, and that in some measure or the other has responded to the market sentiment having improved. The market at one stage was as low as 2,600. Even when the ordinance was issued, it was less than 3,000. The market sentiment since that period of time has to some extent improved. Madam, with these observations, I commend to the Honourable House that our experience of this ordinance has been that this is going to help the market and therefore help the small investor. The House gives its approval to this particular bill.
I think this itself is a scam. If the minister doesn't respond to this fact that the promoters can transfer the wealth which is with the companies into their personal pockets via this mechanism, and the government is helping this scam. Someday, all this is going to boomerang on this nation. We have been trying to do something like this for last several years. First time when the government decided that the public sector corporations should go into the market, buy the shares, and we had Harshad Mehta scam. Thereafter, continuously, we have seen number of occasions on which the government is trying to bring in regulations which is going to affect the market in the manner we will totally destroy our capital market and our capital structure and the capital formation process. This is a warning, and I think the government should respond.
And madam, I think factually also.
Now I have to put them.
Let us bring this into record.
But you
that
have
between
opposed
March
it.
2000 and March 2001, the Sensex shed 1,000 index points. And it is not just after the presentation of the budget that it happened. It was happening for one, so the market sentiments argument that I think this is totally misplaced. The argument is totally misplaced.
1999 amendment.
1,000 points the market lost during 1 year.
Now the whole,
You are trying to confuse us. You are trying to confuse us. But the fact is,
There is a procedural law, madam. You have a buyback system operating since 1999. There is a simplification of procedure, and some honorable member, I would request him to be slightly careful about
facilitate
his
the corporate-
phraseology to say a simplification of a procedure is a
Facilitate the
scam.
corporate promoters. To
not
facilitate
great.
the
The
corporate
Lok Sabha
promoters.
unanimously approved it, and that's a scam.
We are
Give it to
absolutely
the board
clear
of
what you are
directors.
trying
That's
to do.
certainly not procedural.
I have a simple answer or solution to it. There is a statutory resolution opposing it, and there is a bill before us. They both have been discussed. If you want the voting, we can have the voting and solve the problem. Instead of having allegation.
Not of voting. Basically, we don't want to stand in the way of the government. If they want this experiment and hope that it will work, we'll support them. But we only wish that they had not taken the ordinance route. They had gone through the normal legislative process. We would have had a better discussion on it. We would have been able to exchange our views and facts. We are not opposing it. Yes. That's all.
The point which he has made, we have taken very serious note of.
Thank you.
And you will consider it. Now,
I respect the seriousness of the minister and not the government.
it's a joint responsibility. So you have to take the government along with him. Now, the resolution which was moved, Shri Arun Jaitley, you have moved it. Now, the statutory resolution, the motion for consideration is being taken. I shall put the resolution moved by Shri V. Raghavan to vote. Are you going to
I
withdraw?
sincerely hope the Honorable Law Minister will discourage the rush to ordinances. With this hope, I withdraw my resolution.
Has he the permission of the House to withdraw? Okay. The resolution is being withdrawn. I shall now put the motion moved by Shri Arun Jaitley to vote. The question is that the Companies Amendment Bill 2001 as passed by Lok Sabha be taken into consideration. Those in favor, please say aye. Aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it, motion is adopted. We shall now take up clause by clause consideration of the bill. Clause 2 to 4 stand part of the bill. Those in favor, please say aye. Those against, please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 2 to 4 are adopted. Clause 1, the enacting formula and the title stand part of the bill. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it. Clause 1, the enacting formula and the title are adopted. Shri Arun Jaitley, to move that the bill be passed.
But I move that the bill be passed.
Motion moved that the bill be passed. The question is that the bill be passed. Those in favor, please say aye. Those against will please say no. I think the ayes have it, the ayes have it, the ayes have it, bill is passed. If I go, Mr. Nilotpal Basu, if I had gone for the voice, then there was only one voice saying yes and one voice saying no. So I would have to have a proper voting done. That we'll have to measure, that how loud it was. And then we'll have to measure how committed it was. Now we have the Indian, I have one problem before me. There is a bill which Mr. Satyanarayan Jatia has brought before us, the National Commission for Safai Karamcharis Amendment Bill. I went through the bill, there is really nothing in it. I mean, it is nothing in the sense that nothing controversial in it. Now, Mr. Jatia has a problem because the Vice President, the Chairman of Rajya Sabha, is presiding over some function where Mr. Jatia has to be there. It is his program. If the House so agrees, and if nobody is, discussion is required.
Other house also, long discussions.
No, it was very
No,
short
I'm
bill.
not,
It is
I
bill
am
to extend the
never
time
saying
only.
they don't have the discussion. What I am saying,
Madam, it is about Safai Karamchari.
okay,
Have the discussion later.
the whole trouble, just a second. The whole trouble with you is, could you please listen? Yes.
Only to extend it.
It's sometimes the chair has to have the attention also. Or you also have to the attention of the chair. The thing is that there are many bills in between. Now what Mr. Jaitley requested me, that after we finish the succession bill of Shri Arun Jaitley, I should take it before. There was nowhere any suggestion yet you pass every bill. I know you are very concerned with the Karamcharis, whether Safai or otherwise. So your sentiments have been taken care of. Now we'll take, if the House agrees, after Mr. Jaitley's bill, we'll take that. That is the only thing. The Indian Succession Amendment Bill 2001, Shri Arun Jaitley. Agreed.
But now I beg to move that the bill to amend the Indian Succession Act 1925 be taken into consideration by this Honorable House. Madam, the Indian Succession Act 1925 was aimed at consolidating the law relating to testamentary and intestate succession as was prevalent at that time in our country. Chapter 2 of Part 5 of this Act deals with intestate succession of Christians. There are two particular provisions which this bill seeks to amend. Section 32 recognizes the Christian widow as one of the successors to succeed the property of her deceased husband. However, there is an explanation attached to it, and the effect of the explanation is, if at the time of the marriage there is an agreement between the wife and the husband, in that event the wife on becoming a widow will be excluded from her husband's succession. This, madam, was originally conceived to be something which would have been opposed to public policy, but because there was a specific statutory provision in 1925, this has been sustained. We have been receiving various demands that this should be done away from the statute book, and such a provision should have no recognition of this, particularly in the present age. The Kerala Women's Commission, several other non-governmental organizations, and various Christian organizations have been representing to the government that this provision should be, this explanation should be deleted, and a Christian widow should be entitled to succeed to the property of a husband, particularly if he dies intestate. The second provision is with regard to the provisions of Section 213 of the Indian Succession Act. This is intended to bring the Christians at par with other communities in the country. The provisions of Section 213 require, it is a provision which doesn't apply to the Muslims. It also doesn't apply to Hindus, Jains, Buddhists, except a certain category who live in certain 3 of the metropolitan towns. Since there has been no demand as yet in relation to that category of the Hindus, we are not looking at those amendments at the moment. But with regard to Christians, an exception has been carved out that upon the death of a Christian, there is a probate mandatorily required by his successors all over the country. This is a long drawn out process where a Christian heirs have to go to court, spend money on litigation, and then get an order of court to enable them to succeed to their predecessors' interest. Some months ago, I had received a representation which was signed by Christian members of parliament belonging to both houses, about 23 of them, wanting the change in this particular provision. I thereafter consulted various other organizations of the Christians. They were also in favor of this change. The Law Commission, in its 110th report, the Christian Women's Commission, members of parliament, other community leaders have all been requesting us to make a change to this provision, and therefore there is a second amendment which has been introduced, which is to bring Indian Christians at par with the words Mohammedans used in Section 213, so that they are also not expected to go through this cumbersome legal process before succeeding the property of their predecessor in interest. Since this is a provision which seeks to help the community and also delete one provision which is now considered unconscionable with regard to excluding widows from inheritance of a husband's property, I request the Honorable House to take it up for consideration and passage today.